So we have a question for you.
Oh.
Here, I get.
Oh.
For the preliminary vote.
Yes,
The tenants are going to present their range first.
correct. It's the tenant's turn to go first.
Now, does that mean that on the final vote, the landlords will go first?
I believe it's been alternating that way. I'm pretty sure it just happened to work out that way, that it alternates that way.
Okay.
So, yes.
Where do we stand, although it doesn't sound so relevant after our conversations today, on doing anything other than a straight? So we're going to ask the law department to advise us as to, do we give one rate increase for one population of buildings and another rate increase for the other? That was an issue that we were considering last year, which doesn't sound like we're going to care about as much, but...
Yeah, I think that what we decided, or at least what my sense was, that we wanted first to find out whether there would be data that would support. I mean, what we've been told already by the law department is that if you're going to do anything other than an across-the-board adjustment, that if you were going to target a particular segment of the population, that you would have to have the data to show that the needs or burdens on that particular sector were different than another sector, to justify treating them differently. And so one of the research that the staff did, specifically about the percentage of rent-stabilized units in a building, was part of that effort to try to see what does the data tell us, separate and apart from what we might have intuitively thought was going on. And that data, as we've seen, I think doesn't really support, or wouldn't support, certainly from the perspective of the law department, making a distinction in adjustments based on proportion of units, of stabilized units. Now, maybe there are other, we had also talked about doing something based on whether and to what extent owners had taken advantage of other means of raising rents beyond the guidelines. And the initial response that we had from the law department was that that would be legally problematic because it would look potentially, it could be argued that it was contrary to the intent of the legislature in enacting these other methods of increasing rents. So the other thing that I think generally has been a concern is just the administrative feasibility of doing anything other than an across-the-board increase. There's only one, correct me if I'm wrong, Andrew, but historically, the only variation on the theme has been an increase for apartments that have a very low rent, that is different from an increase for apartments that have higher rents. The theory being that those owners, I guess, who had apartments with particularly low rents were more burdened, and it was just unfair. But that's the only variation on the theme that I'm aware of.
For apartments, yeah. For the most part, they were either referred to as low-rent supplements, where an additional dollar amount was added to if a rent was below, say, $300. There was and the percentage didn't bring it above. You could add a certain dollar amount to that. So there were some, and then some were tied to changes in fuel costs, but they was later found that the law changed that board couldn't do that anymore. They used to amend orders sometimes and go back and react to fuel costs changes, but we're not allowed to do that anymore. But for the most part, yeah, so it's a reaction to the idea of rent skewing, where over time, some of these rents were not meeting operating expenses. So that was been done in the past. But really, and then some of the hotel guidelines spoke to a certain percentage of units had to be rent regulated to have any sort of increase. Otherwise, they wouldn't have an increase. But that was done in the, hotel sector, not in the apartment sector. So, yeah.
What about in this era where we took out tenants who pay heat separately? Were those two rates set?
Yeah, those were two different rate sets too. The idea that if owners' costs were bearing, if cost of heating had gone up, should the tenant who's paying for their own heat bear that cost? And it was determined by those boards they shouldn't, and so it was reduced appropriately to tenants who pay for their own heat, which is predominantly electric heat, I think.
Which we don't really have
Which we don't
anymore.
see much of. Yeah, it didn't impact many households.
Andrew, I'm kind of resistant to what Tim Collins said, that the cost to income ratio in other jurisdictions is totally irrelevant to our analysis. Do we have access to data about that, and why? What is your opinion as to its relevance or lack of relevance?
There was a we tried to look in for some of that data. The only thing that we came close to finding was something that was very pricey to pay for, right, Danielle? Yeah, it wasn't
Like CoStar
there wasn't
data or
anything
something?
that was immediately available that we could.
And there's nothing like retail, like there's no other universe of data that just gives us a ballpark, like, REITs. Do REITs report their cost to income ratios in their SEC filings, or I'm just trying to think, like, I mean, this data must be somewhere. I mean, maybe it is only proprietary data, but it just seems like
Well,
it would
New
be
York.
really interesting to know if it's really similar or it's totally higher or totally lower. Like that seems.
We could take another round and look, but
Or would the landlord, would landlord advocacy groups, come, give us that information somehow, even if we can't access
I
it
mean,
directly?
there is some information that was been given to us about from co-op and condos, but I think their expense ratios are different enough that I don't know how much we can. Their expenses are different to the extent that I'm not sure how relevant it is to compare, because their real estate taxes are significantly different, and how they each unit is insured separately by the tenant, I believe. And so there's certain, I'm not sure it's a apples to apples comparison on what ratios they're necessarily operating on. I mean, we do have that information. But I think New York City is unique in that the finance department requires by law that they file income and expense. I don't know if there's other jurisdictions that have that same data source. Like the one place we looked into, it was completely a survey-based, owner, member reported or whatever it was. It
But like an
wasn't.
apartment REIT might report it in their SEC filings.
Yeah, they. I don't know. We'll take another round of look, but our initial, we didn't find anything. But
What's your evaluation of Tim Collins's assessment that the ratio in 1990 is a pretty good ratio to try to mimic?
I don't, I'm not sure what the economic condition was back in 1990 when we go, and we go to that date because it's very reliable data from 1990. I think he refers back to the before rent regulations started, where the rent to income ratio was.
But like what?
I mean,
why?
expense to
yeah.
income ratio was.
Why choose that?
And it was 62%, or 62%. I think watching, I can't definitively say if it's a good number or not a number. All you can say is going forward from there, what has happened. At times it's gone up, and at times it's gone below that over time. And, it usually mimics, either the economic conditions of the city or I can't agree or disagree with his statement.
Yeah, I mean,
I understand your question, though. I get it. Why do
somehow
we do
should
that
have
step
some
one?
standards, not that we have to follow any standard, but like, as opposed to saying, well, it's the data we have, or that's what existed, like, it just seems kind of unsatisfying to say that's the basis.
I don't know, and maybe it speaks more to, people who lend, debt service. What ratio do they look for when they
Interesting comparison.
approve a loan? Now, what differs there is that you're dealing with a building already in place that's not necessarily with debt service and not necessarily, in a condition where the building, an institution would lend to that building because it's not going to be a good investment. So you can't always go by what they expect as opposed to what's actually out there and what's real. I think just looking at data over time and seeing if it's going up or down or, it's the way to track it historically. And
Would it help you if we did an average over the entire period if we had data for to see if it's above or below the average of the 25 years or whatever it is?
So I guess I'm just responding to some of the arguments that the landlords have made where they said, using 1990 as a baseline is totally wrong. So I don't feel like I can really assess that. Or Tim saying, that was a really good ratio, or 1969 was a good ratio. I can't really assess that. Like, what is the context in which I should assess that ratio? I just don't really have a good handle on that.
Yeah, the only thing I can think of is to make an average over the 26 years or whatever it is, and you can see, what's above or below that average, which is a really long period to take an average.
But I guess then the limitation of that is effectively you're tied to where we started,
Yes.
Yeah, so it's
Yes.
kind of, that's consistent with the landlord critique of starting from there. That so I'm just trying to think, do
think
the
their
landlords have a
critique
point
is
that we should
more-
try to address?
I think their critique is more that you're starting at this arbitrary point, and if you had started at a different arbitrary point, it would be a totally different set of numbers. But I think if you made it, I don't know.
yeah, if
Andrew
you looked
can
at it
weigh
over
in.
time.
But except that built into your suggestion is the rent increases based on that starting point. So I just don't, I think you're going to build into your average those historical accidents of when you started doing this, when you started having data or when you started rent regulation. So I'm not sure if it helps.
I mean, even in their own testimonies, they do have starting dates, 1996. Why did
Well, they choose an attractive date for them. I think probably because that makes their numbers look good.
Yeah.
And just with Tim, and he did mention this in fairness to Tim, but our rent index does take into vacancy allowance. The median
Which column? This is
vacancy.
which column?
The second to last column there, yeah. The rent index also takes into account vacancy allowance. So it's just important to know that. If we just did the guidelines, we would be undercompensating owners. I mean, we ran those numbers, so it would be undercompensating owners if it was simply the 1 and 2. So the board has considered these. I guess your opinion is whether or not they considered them enough to compensate for those other things happening beyond the guidelines. But even in those years where the recession threw off our expense analysis in 08, in 09 and 2010, they still tried to, compensate for vacancy. That was always part of the commensurate and in there. So again, if you pull that out, the board it shows the board has made a very conscious effort to consider vacancy, which is not under our control, but we do try to consider it. So I think most board feel that we should, I guess. It's up to you guys, but.
Can we see, maybe we should look at his recommendation from last year.
He made the same recommendation
Zero,
last year.
rent freeze, yeah.
He
No rent
has,
freeze.
I mean, and he may have even made a rollback recommendation. He may have last year.
This year he said zero.
I think this year he's just said rent freeze, or was I wrong?
Freeze.
He said rent freeze. Yeah.
But I think it was based on the 2015, 2016 numbers that he projected, like his difference. Yeah. But they're all based on.
I guess they met.
So another question, Andrew, is when do people have to get their proposed preliminary range guidelines to you?
They don't.
They
That's
don't.
only for the final, yeah. So we could talk briefly about that, too. So this, again, is the preliminary. You bring whatever numbers you want to the table. It doesn't have to be, this is not setting a rule. It's a preliminary guideline. So whatever you bring that night and whatever gets the 5 votes goes. That's fine. That's all legal and on board and up. So it's only when we do the final vote that we need to publish 72 hours prior to our meeting on our website the proposals that are going to be considered. And if one of those proposals passes, we're fine. If none of those pass and a new proposal is done at that meeting, then we have to reconvene. We have to wait at least 72 hours, and we have to reconvene to approve that. So that's the idea, and we can throw out 150 different proposals, and that's the good thing that last year I think there were 6 proposals. One of them is most likely, bless you, since we've had to be under that law, we've always passed one of the proposals. I think we've done it 4 years now. So, but this one, it's all fair game and whatever you want to bring that
Okay.
day. I don't need anything from you.
We're not necessarily legally tied to anything that actually gets the 5 votes for the final vote. I don't know, I look at you guys have the up and down within the range.
Yeah, we've always been within the range.
Or
Outside of
you've
the
also been,
range?
the same or down or up from whatever numbers in the last.
Before they gave ranges.
Oh, before the range. Yeah, very often it was the same. Occasionally it was down or up, but not by much.
But not, we're not legally bound to whatever gets voted at.
Well, we've never been legally sued about that. I mean, the idea, remember, it's public comment, so the idea is that there is a range, and that's what the public is commenting on. If you do a range of 0 and 2 and you end up at 10, then there's an argument that the public did not comment on that. If you're in a 0 to 2 and you go 2.5 or minus 1.5, I don't know. It could be,
Yeah.
there could be a legal challenge there, but
It's best to stay within the range.
it's best to stay within the range, but.
Don't you also take the position that ranges should be tight, rough relative, that a broad range, your position is a broad range doesn't give people enough guidance? Is that-
Well, that's the other argument. Yeah, if you do a range from 0 to 10, which is always what the MTA does for my Metro North rent increases, it's amazing. They have public hearings where it could go up, 30% or 2%. And that is not really something that you can publicly comment on either because it's too big of a range. So it's, you want to keep it, probably historically what the board has done.
It has gone, the ranges have been.
Up to, like-
4% different almost.
Yeah, there's a few years they were pretty wide, but you want to bear that in mind too. But
Yeah. 4%, yeah. Seems to be the most.
so they're here.
Oh, good.
Yeah.
It is.
Yeah, last week's meeting.
It's great.
Hey, wait. You weren't here.
Trying to look through it. I tried quietly to look through it. Can't remember everything. I feel like I have a worse memory. I try can't remember my anniversary, but I can remember rent increases.
Don't tell your partner that.
And just a,
Summer. It's around my partner's birthday, I think. I don't remember when we got married. It was like.
oh boy.
I feel like I've always like been tempted to like write it down somewhere.
I know the month.
And just a reminder to the two new members that you can meet up to 4 board members outside of public meeting. More than that, it would constitution, and so you'd be violating the open meetings law. So, even on the phone, yes. So, bear that in mind. I don't want to hear about it.
Are you a mandated reporter?
No. You want to call
So,
it?
I don't know, we lost.
We lost Larry, but we can bring up
Larry,
the
yeah.
other folks if you want. He just went to the bathroom, I think.
We should give him that accommodation. There might,
I think we might have to like switch around.
I put this all on Andrew because he's the one who puts out the.
I don't know how I ended up here.
Oh yeah, that's the gender.
because you moved up.
I don't know. David, do you feel okay?
I'm very okay. I'm very okay with that.
Oh my god. I think it would be really weird if it was like the whole side of that.
Yeah. No.
Do we have any dirt on who the new member's going to be? Is that person finalizing or
They're close to finalized.
finalized like they've agreed and they're going through Department of Investigation? So that's mostly a positive.
Will it be at the next meeting, ideally, or
Yes, that's what I'm told.
do they have? They have to be. Do they have to be legal? Do we have to have a full board?
No, we just have to have a quorum.
Quorum?
I don't want to remember.
But it's not a good idea.
Definitely doesn't look
Doesn't
good.
look good.
Especially for this mayor, it doesn't look good.
You guys get the deluxe edition.
Hi. Hi, Judge.
Hi, nice to see you.
Thank you.
You guys getting the deluxe package. I
Great.
spared you guys like huge package.
Oh, okay.
Just do one at a time.
That'd be great.
Thank you.
Thank you.
You have to do one for Andrew and one for you.
Okay, thank you.
I don't know, I haven't been trained in this job.
Thank you. Some water? Okay. Sure.
Oh, I'll take
Oh,
some more
sure.
if you don't mind.
Sure.
That's perfect, thank you.
Drink so much water.
Thank you.
Wow.
A lot of trees going down
Commissioner
here.
just resigned from Landmarks.
Oh, really?
That's why they wanted the room, because there's just sudden announcement that was coming. And that's what it was. They're commissioners.
Well, that's interesting.
Yeah, it's a pretty
Big deal.
big commission. Yeah, it's one of the more sought after.
Yeah, I can imagine.
Yeah, landmarks. People
Yeah,
like
it's
the
not like the
landmarks more.
RGB ring.
Hey, if you want to throw your hat in the ring, I will not.
Yeah,
be
right.
least
Maybe I'm ready for a move up.
bit. The pay is out. But I think it's a full-time gig.
Really?
I believe so.
Okay, I think we can get started. Welcome. Have you decided among yourselves what order you'd like to speak in? Good, so let's go.
Testing, okay. Well, I guess as my tradition, I want to thank you just for this opportunity to come present on behalf of the SRO tenant community. I've been coming down for over 30 years and probably testifying the last 10 to 15 for this panel. And I also want to thank you for your service, which I do every year for a largely thankless job, because I know it's a difficult job. And I know that tenant and landlord reps are going to be battling for the hearts and minds of those 5 public members and where we end up. So for the new members, I prepared a packet, I call it deluxe packet, because I have a lot of history about SROs and what they are, which we've expounded upon numerous times. And I guess we're going to request an individual meeting with the new members so we could talk in more detail about what SROs are, its history, et cetera. And I'm going to largely focus in on the new memo that was produced. And some of the practice in the buildings, looking, how many buildings, units, average rents, practices, and then colleagues will fill in on some more of that, as well as some of the demographics about the tenants themselves and the hardships they face. So with that in mind, in the packet I gave you, the first page, just as a summary, is from DHCR. It's a Notice of Rights and Duties, because an important thing to remember when we're talking about SROs is the distinction between the transient tenant and transient uses of these units and the permanent tenants. Unlike apartments where people have a lease and are protected from rent stabilization from the get-go, you'll see in this notice, you only become a permanent tenant in an SRO if you've lived there over 6 months or you actually had a lease to begin with. We always called it the transiency loophole, and from the inception of the rent laws, we were trying to get that closed, but we never was successful. But because of that, it allows SRO owners to rent out these units legally to tourists, to colleges, to special needs populations placed by the city, and that's where they generate a lot of their income, which you've seen fit not to give it an increase to the rent stabilized tenants, because these are very, very profitable buildings at this point in time. And I think a lot of the data will bear that out. So just as a quick refresher, there was 165,000 units of SRO housing in 1971. The city actually encouraged the demolition and conversion of SROs. They were seen as substandard housing, and some people thought the tenants were also substandard, and they weren't necessarily cheered on in different communities. So with J51 benefits and others, there was a lot of demolition and conversion to co-ops. Starting in the early 80s, and by the mid-80s, the city realized we can't just keep demolishing SROs. We have a huge homeless population growing. The law projects were created in 1981 to serve SRO tenants. And then 1986, there was a report done, the Blackburn report, in a census of how many were left. And they found 65,000 units left in 1986. So from 71 to 86, over that 15-year period, about 2/3 of the stock was demolished or converted. Then it doesn't take a rocket scientist to figure out why homelessness exploded in the 1980s. City kind of, turned and now is encouraging the preservation of these units, and that led to the whole growth of the supportive housing movement and nonprofits running a lot of these buildings. Our current estimates, it's hard to tell. We're thinking 25 to 30,000 units left. There's just really no hard data to verify that at this point in time, but that's what we think. The majority are in Manhattan, and the bulk of the units are actually in community boards 4 and 7 on the west side, particularly a lot of the big hotels. And the rooming houses are kind of scattered around the city, but they're also a big, important part of that stock. Again, I mentioned a key distinction was those transient versus the permanent tenants. So I showed you that first page of the DHCR notice. The second and third page in there is from the explanatory statement that accompanies the rent guideline board orders that you guys issue. And two things I want to just point out on there are the 5 different types of SROs. Residential hotels, which are apartment hotels that had hotel services, rooming houses, which are generally less than 30 units is the definition of a rooming house. Then you had single-room occupancy buildings that were former apartment buildings chopped up into SRO units, Class B hotels, and then the good old lodging houses, which are those little cubicles with chicken wire ceilings with people rented for a night, down on the Bowery and elsewhere. So they were the low end of the SRO stock.
Hey, Larry, I'm sorry.
Sure.
Have you seen a lodging house they still exist?
There might be a handful downtown.
Yeah, they do exist. There are a handful downtown, mostly on the Bowery, and that's sort of more MFJ's catchment area. And there's a couple of them are pretty big. There'll be 3 or 4 stories of the units with a lot of cubicle units packed in. And then, interestingly, there's actually a smaller amount of them out in Brooklyn in not as big a buildings, but same exact physical arrangement. Those are under sort of more intense pressure, interestingly, than some of the ones in Manhattan. But there's a scattered few out in Brooklyn that we know of as well.
And then there's a lot of so-called three-quarter house or illegal SROs. And the estimates are there are more illegal SROs in New York City than remaining legal ones. So that's another important part of the low-income housing stock out there. So these are the different types of SROs. And the other thing to note in the explanatory statement is the special note about provisos. When there have been increases or adjustments for SRO tenants, they've been accompanied historically by different provisos. One being warehousing, if a significant portion of the units were being withheld from the rental market. We basically argued that if the landlord needs rental income, rent the empty units first, and they could qualify for the increase. And the others is through that transiency loophole, as we called it, because they can rent out to placements by the city, homeless families, HASA places lots of folks. It's used for sheltering folks. Colleges net lease a lot of units, and we've presented data on that, and my colleagues will talk about that. And then there's the tourism, either through Airbnb or hotels having their own websites. There's a lot more money to be made through tourism, renting to the city, or leasing to colleges. NYU rents, Columbia. On my block is 2 SROs. It's largely American Music and Drama Academy, AMDA. They rent 4 SROs, actually, basically as dormitory students for expiring performers. So that's that on my quick overview. In terms of the memo, the memo was produced last June of 2017, and it's based on data from DHCR from 2015 and 2016, so there's a little bit of a lag. And then Andrew did use other sources of data, at least for analyzing hotels, in addition to the rooming houses. I think a little different from prior memos, the prior 6 memos, I think. The board did break it up between rooming houses and hotels, which wasn't done in past years. And I just want to thank Andrew for the work involved with this, because there's so little data out there that we have, and a lot of the data I was able to extract from here does verify of a lot of what we've represented to you. So if you can look at the legal size chart that accompanies the packet I gave you, I pulled out some of the data there, and then I'm just going to talk you through it, I guess. So again, it was broken up into both rooming houses and hotels. The rooming houses were those SROs that had less than 30 units. And let's see, the number of buildings was 174 buildings that had submitted rent registration information to DHCR. And I think that's a big undercount. I think there's a lot of rooming houses that are not registered. Of that, there were 4206, over 4,000 units registered with DHCR. 2811, almost 3,000 were stabilized. 750 of the units were vacant, so that's about 17.8%. And I'll just point out that that proviso saying if 15% or more is warehoused, that means they would not qualify for the increase. And then another 655 units were temporary or permanently exempt, so that's about 15%. So of those 174 rooming houses, 25 buildings or 15% said they were totally exempt from rent stabilization. Another 94 buildings, or 54%, had greater than 15% of the units not rent stabilized. So basically, 69% of the units wouldn't qualify for the rent increase under the proviso. The vast majority just wouldn't qualify. We've maintained that in the past, but it's good to see data kind of backing that up. In the case of the hotels, there were 83 hotels that registered with DHCR, representing 6,730 units. Over half of those, 51%, or 3,428 units, were temporarily exempt, means they were rented out for non-stabilized purposes. Only 35% were actually occupied by rent-stabilized tenants, and another 11% were actually vacant. So adding them up, of those 83 hotels, 13% were totally exempt, 36% would not qualify because they had over 15% exempt. And in the notes, apparently those 41 buildings that reported some exemptions, they were 49% of the buildings, but actually represented 70% of the units. So both in the case of the rooming houses and the hotels, in one case, 69% of the units, the other case, 70% of the units would not qualify for rent increase under the proviso. What I found interesting, these numbers were very low. We usually see the registration data with DHCR somewhere around 17 or 18,000 units. And this doesn't add up anywhere near that between the two. But Andrew apparently looked at Department of Finance data and other information and found that just the 83 hotels actually had 17,000 units and 841. So they only registered 6,700, but over 17,000 were actually in those buildings. So I've always maintained there was an under-registration with DHCR, and your data really does verify that. So I guess what I wanted to end in is the other little piece that I put together in my packet is from the Furman Center. It's called 21st Century SROs. And it's the first time I've seen some really good data on the square footage, how much it costs to run an SRO, and we've maintained that it's cheaper on a square foot basis to operate, and it's more profitable on a square foot basis in terms of income. And this study really bears that out. If you look through the charts in there, it really does reflect that. And the point of this report was to call for a relaxing of the building code or reforms to it to allow for new SRO construction because of the desperate need for affordable housing, particularly for single households in New York City. So I'm going to close there. I did want to say something more about the decorum of the theater that occurs during the hearings, but I'm going to wait till my colleagues present and we'll close on that.
Okay, who's next?
Good afternoon, members of the board, and thank you as well for giving us the opportunity to come here and testify before you. This is my first time, quite different from Larry, but nonetheless a privilege. My name is Lana Pelletier McCrea. I'm a staff attorney with the Goddard Riverside Law Project. I represent a number of SRO tenants, and I've seen them, the units as well, a number of them. The Law Project has provided free legal representation and organization support to tenants living on the west side of Manhattan in SROs for over 30 years now. So I would like to say that I celebrate the board's vote last year in favor of a 0% rent increase for SROs. I think that this was a fair decision that took into account the need to maintain rents affordable for low-income New Yorkers without compromising the ability of building owners to profit from their investments. And while Larry got into more of the nitty-gritty, I'm going to talk about the conditions of SRO tenants in terms of affordability and the conditions quite differently for SRO building owners. So the picture painted in the 2018 income affordability study is alarming for low-income New Yorkers. And the study shows a consistent and troubling pattern of low-income New Yorkers getting left behind while the city grows. As Leonard Cohen sang, the poor stay poor and the rich get rich. The New York City's income disparity ratio ranks near the highest nationwide, with the top quintile, that's the top 20% in average household income, making a whopping 27.49 times more than the lowest quintile, the lowest 20%. That's a massive differential. And for the 8th consecutive year in New York City, employment levels have risen, albeit at a slow pace. But meanwhile, things are not so sunny for low-income populations in the city. New York City homelessness levels have risen for the 9th consecutive year. Each night in 2017, an average of almost 60,000 persons stayed in New York City Department of Homeless Services shelters. That's an increase of 697 persons from 2016, and like I said, that's been increasing steadily each year. So for this population that has not seen the benefits of the steadily growing economy in New York City, SRO housing is critical. SRO housing is a housing of last resort for low-income individuals who would otherwise be homeless, who would be perhaps living on the street. Thousands of hardworking people, as well as a disproportionate number of elderly and disabled people, call an SRO their home. If the economic situation is difficult for low-income New Yorkers, it is dire for most residents of SROs. Many rely on SSI, disability, pensions, SNAP benefits, and similar resources as their sole source of income. Tenants routinely report incomes lower than $10,000 per year. And for an individual with an income of $10,000 per year who is already paying 50% or even more of their household income in gross rent, an increase of just 2% in rent could easily cause substantial financial distress, even though it may not seem like much. On average, housing in New York City is not affordable. The United States Housing and Urban Development benchmark for housing affordability is a 30% rent-to-income ratio, and the median gross rent-to-income ratio for all tenants in New York City is 33.7%. So almost by definition, it's not affordable. And that ratio has remained virtually unchanged since 2011. And the ratio for rent-stabilized tenants is even higher at 36%. And a third of rental households pay more than 50% of their household income in gross rent. And we, serving SRO tenants in the Upper West Side community, observe this reality. We see people who frequently pay a substantial portion of their modest incomes on rent. And this housing crisis is not just about affordability, it's about availability. The citywide vacancy rate was just 3.63 in 2017, and this is critically low. But if you look at it, it's actually a far graver situation for low-income New Yorkers, as the vacancy rate varies widely among different monthly asking rent levels. So for example, the vacancy rate for apartments going for $2,500 or more per month was assessed at 8.74%, whereas for those costing $800 or less, it was at a critical 1.15% in 2017. So widespread practices of SRO buildings discussed further below, such as warehousing, will seem even more egregious through this lens of critical affordability and accessibility availability. So, conditions for SRO building owners. The low vacancy rates in New York City suggest that building owners have little trouble renting out their units to permanent tenants, but SRO landlords have turned to using their properties in other ways to profit substantially. That includes renting to tourists legally and illegally, and I'll talk about some of the most egregious examples of that in a bit. Net leasing to New York City colleges, and entering into lucrative contracts with the city. So a 2010 report showed that 1,336 SRO units were lost between 96 and 2010 in the district that we serve, Community District 7 alone. So while SRO owners are making profits, some of them are permitted to offer transient rentals, but even when renting legally, the vast majority never inform their guests that the rooms are subject to rent stabilization or that guests could become permanent tenants. And despite the strengthening of laws prohibiting illegal hotels in 2010, they're still rampant. And some SRO landlords do so with astounding, blatant violations of the law. The Broadway Hotel and Hostel, a residential SRO building located on 230 West 101st Street, lists daily rates for rooms on its website that correlate to monthly rents of over $5,000. They know very well that that's illegal, that's well over the rent-regulated rate, but they're doing so blatantly. You yourself can go to that website today and see those listings that are illegal, and they make massive profits. Another infamous illustration that the more senior members of the board might remember, but nonetheless important for new members, is Imperial Court. We at Goddard are still involved in extensive litigation with Imperial Court for their practices. The Mayor's Office for Special Enforcement has issued over 100 violations. They've got tens and thousands, so many fines from the city, and nonetheless they continued to rent short-term rentals listed on various websites. And the owner, Michael Edelstein, was quoted in Manhattan Express as saying, "We're billionaires and we can afford to keep this building empty for the rest of my grandchildren's life, and it will not affect our financial lifestyle one bit." He continued, "Nobody can force me to rent these rooms. They're going to be left vacant. Nobody is going to have the benefit of low rents in that building ever again." On the record, saying that. And we like to use that example because he just blatantly violated the law over and over and over again, and that building sits largely empty to this day. So SRO owners use websites like Airbnb to rent stabilized rooms, sometimes mostly illegally. The Imperial Court is one example of used Airbnb, and Attorney General Eric Schneiderman issued a report in 2014 finding that 72% of all Airbnb rentals in the city are illegal, and commercial users control a disproportionate share of rentals. 6% of hosts supply 36% of units and earn 37% of the revenue. So, and a lot of these, from a more recent report from 2017, showed that so-called impact listings, which are commercial short-term listings for an entire unit or home, were if all of those listings, the impact listings, were added to the residential rental market as vacant units, the number of vacant rental units in New York City would increase by 10%. So that's a pretty substantial portion of a very critical housing market with a very small vacancy rate. So in addition to profiting off of illegal short-term rentals, SRO owners also keep affordable units off the market by a practice called warehousing. This is keeping whole or substantial parts of their buildings empty, largely on purpose. Tenants are harassed, evicted, or die, and their units are removed from the market. Owners refuse to rent, as we heard from the owner of the Imperial Court. Sometimes this is because they want to deregulate it. Sometimes they want to more easily obtain certificates of no harassment. It's easier to get certificates of no harassment when there are no tenants for you to harass. And some, as we heard, are just doing it out of pure spite, it appears. In the Imperial Court, for example, it's a massive 227-room hotel, and the large majority of these are empty. The effect is a drastic and harmful reduction of affordable units for rent in the city. So to give an example of how widespread the problem of warehousing is, in the Law Project's catchment alone, we are aware of several buildings with a large number of vacant units. For example, one that I was recently made aware of at 719 St. Nicholas Avenue, only 2 tenants remain in a 13-unit building, both of whom the landlord has recently taken to court trying to evict them, the 2 remaining tenants. The rest are empty. And in Imperial Court, 63 permanent tenants are housed. In the Alexander, 4 permanent tenants are housed in a building with 114 SRO units. Camden Hotel, just 1 permanent tenant is left. I have not confirmed if that tenant is still there, in a building with 207 units. So since we just want to paint that picture to demonstrate that since, based on this widespread practice of warehousing, owners certainly don't deserve increases in rent from this board. An increase would bring potentially catastrophic consequences for vulnerable and the most vulnerable population of New York. This is the last portion. I will urge the board to vote a 0% increase for SRO tenants. Rent increases for tenants can't be justified in this context. Many SRO buildings earn the vast majority, as Larry stated previously, from sources other than renting to permanent rent-stabilized tenants. And rental income from permanent tenants is often dwarfed by the staggering profits that landlords make from legally or illegally operating tourist hotels, student dormitories, and lucrative contracts with city agencies. And additionally, I would like to urge the board not to pass a proviso such as the one passed prior to 2012 that permitted rental increases in buildings that had a certain percentage of occupancy. Warehousing is not the only issue here, and percentage of occupancy is only one of many common practices affecting SRO buildings that should preclude rent increases. And provisos, as we have seen at the Law Project, may cause additional problems. Based on our experience, tenants have frequently been forced to bring complaints to challenge illegal increases. We've seen a pattern of landlords taking advantage of legal changes in illegal ways. So our office in particular challenged numerous illegal rent increases in years when provisos had been in effect. And in the past 6 years, with 0% rent increases and no provisos, the number of illegal overcharge complaints at our office had to file on behalf of SRO tenants has decreased dramatically. So the risk is too high that tenants would face similar illegal increases if a proviso were passed, and it's too high that landlords would take advantage of a proviso. And also, not to mention the fact that because of the widespread practice of warehousing and alternative uses property owners make of their buildings, the large majority of SRO buildings would not even meet the proviso criteria to qualify for a rent increase. So we encourage you to vote for a 0% increase for SRO hotels without any proviso. For all the reasons presented, we do not believe that owners of SRO buildings should be rewarded with a rent increase this year. And we urge you to vote for a 0% increase with no proviso and protect this vital housing stock and its tenants. Thank you.
Thank you. Mr. Sullivan.
Thank you. My name is Brian Sullivan from Mobilization for Justice. Like my colleagues, I'd like to thank the board for hearing us this afternoon. This is a sort of large, vulnerable, and often misunderstood form of housing and population in New York City, so we really appreciate the opportunity to talk about it with you. For the past few years, the board has authorized a 0% increase for SROs, and honestly, not much has changed this year. The same exact circumstances that warranted 0% in years past are true today. And so 0% increase for SROs continues to be important. As you heard from my colleagues, the rent stabilized SROs that will be affected by this board's order is the housing of last resort for some of the most vulnerable of New York City's residents. They are people on fixed incomes, working poor people who have exceptionally low wages, people who even a small change in rent could spell catastrophe, financial catastrophe, and even homelessness. It is really, when we say housing of last resort, it means you're either living here or you're living in the shelter system. And the sort of margin of most of our clients' budgets and finances is razor thin. They're just barely getting by. I think it's also worth pointing out that the units we're talking about here also tend to be very small. We were talking a moment ago about the sort of cubicle style chicken wire ceiling. Those tend to be the smallest, but even bigger SRO rooms are, at best the size of a small studio. We're really talking about very small spaces, and they tend to be fairly densely packed within a given building, meaning that if a landlord didn't warehouse the building, if they rented out all the rooms, even if individual rents are small, the ground rent they're able to collect is actually quite high because they're so densely packed, because you get more units in a single building. And on the other side of that equation, the tenants are paying a lot for a very small amount of space. It may be a small absolute figure, but it's a large portion of their budget, and it's a lot per square foot. We think we want to humanize the tenants that we serve, and we do want to pull on your heartstrings here. But as my colleagues have pointed out, it's not just a matter of your heartstrings. The SRO owners have consistently failed to demonstrate a need for an increase. Certainly, they've not demonstrated a need that outweighs our clients' needs or SRO tenants' needs for a rent freeze. That need is acute, and it's very disproportionate to the owner's needs. As my colleagues had pointed out, there's the issue of warehousing in larger buildings. Perhaps the board is interested in the situation in smaller buildings. MFJ, because we serve the outer boroughs and the east side of Manhattan, tend to see some of the smaller SRO buildings, not the large scale ones. And there's a couple things I'll say about those smaller buildings. One, many of them are located in gentrifying neighborhoods where there's really no increase that would make it worth it for the owner to not aggressively push those tenants out. In other words, if they can evict the tenants, they can convert it to, say, a very high value single family home, something like that. That pressure is so intense that a 2% increase, a 5% increase, a 30% increase in rent isn't going to affect the owner's sort of underlying financial incentives there. Furthermore, we see this sort of intense effort to push people out of those smaller scale SROs, and you see this in, for example, the certificates of no harassment, where it's a document issued by HPD, Department of Housing Preservation and Development, and SRO owners need a certificate of no harassment in order to conduct certain renovations in a building. We get a list every so often of the SRO buildings that have applied for certificates of no harassment, and we go out and try and hand out flyers and see if there's been any harassment. And in the vast majority of circumstances, 99% of the buildings, the tenants have already vacated by the time that this application goes through. What that says to me is that this pressure to convert these SROs into more valuable single-family homes is so intense that owners have already taken massive efforts to push them out, push the tenants out, and there's really no rent increase that'll change that dynamic. Now, that's all the things that are the same. I just want to mention briefly two things that are new in the past couple of years. One is the Furman Center report that Larry had mentioned, and I think it's really worth looking over because in addition to the things that Larry had highlighted about the findings, one of the findings is you can successfully operate financially viable SROs. The hurdles are not the increases, the rents that are sort of controlled by this body. The increases are, the administrative code and the multiple dwelling law. They're things that this body has no control over. What this body does have control over is the rents of those tenants who are currently in SROs. And again, they can't afford an increase. The second thing that's, I think we're seeing that maybe isn't new, but really is coming to light is the illegal units. Especially in Brooklyn and Queens, there are, it's actually tough to say how many, possibly hundreds of thousands of illegal subdivided 1 and 2 family homes that are SROs in all but name. They are, small rooms, you'll have like a floor of a single 2-family home that'll be divided into as many as 10 rooms, 10 small rooms. The need for that sort of housing amongst New York City's lower income population is intense. So intense that this entire market of illegal units has sprung up. If this board increases rents, the tenants in currently regulated units will be forced into that illegal market. Now, there's a lot to say about that illegal market, but I think one thing that we know for sure is that it doesn't have the level of oversight that the current legal SRO market has. And so if tenants are forced into that, they face a whole they're vulnerable at a whole new level. It's more easy to evict them. I think there's probably fire code problems. They're probably more physically at danger. This board does have the power to not push tenants in that direction. And that's yet another reason to not increase the rent in the legalized, legal SRO stock. So for all these reasons, we ask that the board continue in the sort of trend it's had over the past few years of a 0% increase. The SRO tenants really cannot afford it. Thank you very much.
Thank you. Any questions for our presenters?
Mr. Sullivan, just one question on one of the figures you threw out at the end, that you think that there may be possibly hundreds of thousands of the illegal SROs in the outer boroughs. Is there any, I'm not questioning your judgment, but just asking, is there any evidence of that?
Yeah.
And what is that evidence?
There was a whole report written by Jill Hamburg, who was one of the co-authors of the Blackburn Report in '86. I didn't bring copies of it. I certainly will. I didn't want to save some trees. But I'll produce the executive summary for you guys and send it down to the board, because she did a really good job with some others documenting how extensive it was.
Thank you.
Is that the Chaya one?
No, it's not.
Oh, and there's another report that only focused on Queens, and it was by I'm not sure who authored
It's
it. but
Chaya. No,
Chaya is
they serve the South Asian community. And
they found, in Queens alone, I think they found 150,000 units, or excuse me, not 150,000 units, that 150,000 people were potentially being housed in illegal basement-style units. So when you expand that to Brooklyn, and the sort of units I'm talking about tend to be much denser than the basement-style units, it seems likely, the figures are incomplete at this point, but it seems likely that it is much more than that.
Is it reason? I'm just asking again. Is it reasonable to put the illegal basement conversions in Queens in the same category as an SRO? Is that a reasonable thing, or?
Well, that's what SROs were. The rooming houses were largely 1 and 2 family houses that there was a legal process to divide them up. After World War I, there was a shortage. After World War II, there was a shortage of housing. So they allowed for these buildings to be broken up. And big apartments also got broken up into rooming units. But that's what's happened. Since '54, you're not allowed to create new SROs. But the need is still there. So I guess particularly in Queens, and huge immigrant communities are served, that they've called it the base campaign. They want to be able to legalize those basement apartments and bring them up to codes that they're safe and not fire traps. Every once in a while, the city will crack down on enforcement because a fireman gets hurt or killed, and we also got to look at how to make these places safe and legalize them, because there's such a need. If they vacated all those illegal units, where would they put everybody? The shelter system would triple.
And sorry, one other point there. I feel like the closest analog in the world of SROs that the RGB increases would cover are, you'll have these brownstones where from the outside it looks like a brownstone. If you go inside, maybe each floor is 2 units, 3 units, something like that. It's fairly similar to the layout of a basement unit. It's certainly not the cubicle, and it's even sort of more spacious than, say, in a large hotel on the west side or something like that, but fairly analogous to those basement units.
And it's interesting, if you're looking at the report, the firm report, they talk about the size of the units and whether it has a bathroom or shared kitchens, and they go through the costing out of how much it would construct and everything else. Those are still pretty big units. The old laws, 80 square feet was the minimum for one, 130 square feet for two. So the micro units, when they're talking about 300 square feet, are palatial for most SRO tenants. But of course, the bigger the unit, the less units you can squeeze in. So the Furman report really tries to go through and figure out how could you really maximize the number of units, but not going back to those old standards, which was so small. So it was a really interesting report, and I'd like to see what comes of it. I know we're almost out of time, and I just wanted to mention just something a little about the decorum and the heckling and the shouting and the what goes on at some of the rent guideline board hearings. We actually had a meeting with Judge Roberts earlier this year because there was some concern was raised about the need for potentially maybe bringing in police or more security. And we're thankful the board is not going that route, but we've had very thoughtful discussions as well. But the point is, we're a broad, diverse movement. There are people going to be far more militant. Other people want to sit and listen. But they really do feel that they are lending voice to the voiceless, and they're there representing their building and their communities. And people do get very passionate. And like I've said last year, don't take it personally. It is part of the drama and the theater of what goes on. We are going to be talking to our colleagues, and we'll do our performance art, as it were, at select times, and we're going to do our best to urge people to listen and hear the testimony as well. But don't paint a broad stroke. The wonderful tenant reps are not responsible for every tenant that shows up. They do their best. They were booed last year by the tenant reps when they proposed a modest increase. So you could just see that, we are a diverse movement, and just try not to take it personally as best we can. And we also want to get people in there a little quicker and not to play out our rallies outside and then delay all the proceedings. So if we get into Cooper Union early and we're doing a little theater inside before we start, it's okay. And then we'll get down to business. I know, but often a couple hundred people try to get in the door at 7 o'clock. It means you have to hold proceedings up a good 45 minutes or more. And anyway, we're going to have a debate in the tenant community about what we do and how we go about it. But bear with us and keep your eyes on the prize, the data and the figures. And on that front, I think apartment tenants as well deserve another rent freeze for all the reasons you probably heard earlier from Tim Collins. And I don't see any evidence. I think it's just fake news, the RSA telling you that there's more distressed buildings and more hardship out there. I know there's a lag in the data, but I don't see any evidence that that's true. The pendulum has not swung the other way yet, where landlords are now distressed. It's still really much the tenants who are feeling the burden of those high rents in the city. So anyway, thank you, and look forward to the hearings and the final vote.
Thank you.